1. The present revision petition has been filed by the petitioners against the order dated 29/8/2020 of Bihar State Consumer Disputes Redressal Commission, Patna, for short, the State Commission, in first appeal number 1546/2012, whereby the appeal was partly allowed. 2. Complainant respondent purchased a Farm Tech 35 Champion tractor bearing registration number BS 12A0908 and took a loan of rupees 3,23,255 from the appellant bar opposite party. The loan was to be repaid in 14 half-yearly installments of rupees 39,250. According to the appellant, complainant paid 6 installments. Seventh installment, which was due in May 2010, was not paid by the complainant on time. Opposite party issued recalling notice on 28/7/2010, whereby the complainant was given 7 days time to deposit the payment. Thereafter, on 13/8/2020, the appellant seized the tractor. In order to realize the loan amount, the petitioners bar opposite parties auctioned the tractor on 1/10/2020. Alleging deficiency in service and unfair trade practice on the part of the opposite party, the complainant filed a complaint before the district forum with the following prayer. Therefore, it is requested that the complaint be allowed and the amount of rupees 42,000 along with interest to be recovered from the opposite party pertaining to damages occurred due to lack in service, compensation for mental agony and expenses of present case, and the tractor of the applicant be released. The opposite party to be further directed to produce the loan account details. Any other relief which deems fit and proper to this honorable forum may pass in favor of applicant. 3. The complaint was contested by the respondent bar opposite party. It was stated that since the complainant neither replied to the notice nor deposited the loan amount within the stipulated time, the tractor was seized by the petitioners and the loan amount was adjusted by selling the same. 4. The district forum, after hearing both the parties and perusing the record, directed as follows. Therefore, the complaint filed on behalf of complainant is disposed of in such a way that the opposite party has to pay the deposited amount of rupees 2,46,678 along with the interest of 9% per annum from the date of payment last installment to the date of payment within 2 months to the complainant. The opposite party should pay the amount of rupees 5,000 against financial and mental agony to the complainant. The demand notices were sent by the opposite party to the complainant in respect of recovery of the loan is also set aside in view of their act of illegally possessing and selling the tractor of complainant. The complaint expense of rupees 1,000 is decided, which shall be paid by the opposite party. 5. Aggrieved by the order of the district forum, petitioners bar opposite parties preferred an appeal before the State Commission. State Commission observed as follows. Therefore, the appeal is partly allowed while amending in clause 12 of order of the forum that the amount compensated by the forum to the respondent is reduced to rupees 1,30,423 in place of rupees 2,46,678. The appellant should pay the above said amount to the respondent along with 9% interest per annum from the date of payment of last installment to the date of payment. The order in respect of mental agony amount of rupees 5,000 and case expense amount of rupees 1,000 passed by the forum is upheld. The parties shall bear expenses of this appeal in its own. 6. Aggrieved by the order of the State Commission, petitioners' opposite parties preferred the present revision petition, had the learned counsels for the petitioners, and carefully perused the record. 7. Learned counsel for the petitioners' contention was that the tractor was seized as the complainant did not pay the installment amount in time, nor he replied to their notice. Petitioners themselves admitted that the complainant had paid 6 installments in time. A recall notice was issued on 28/7/2010 and the tractor was seized on 13/8/2010. Learned counsel for the petitioners admitted that the auction notice was also given on 13/8/2010 itself after seizure of the tractor. In a tiring hurry, the tractor was seized, causing great hardship to the respondent. Merely based on an apprehension that the respondent would become a defaulter in future, the learned counsel for the petitioners stated that action was taken to seize and auction the vehicle to realize the dues. Apprehension of the petitioners that the respondent complainant would become defaulter in future cannot be a valid ground for seizure and auction of the tractor. Hurried seizure of the tractor and auctioning the same on the basis of assumptions and surmises certainly amounts to unfair trade practice on the part of the petitioners. 8. In view of the foregoing discussion, I find no infirmity in the impugned order of the State Commission. Revision petition is dismissed.